Jim Huffman from Lewis and Clark in Portland. Sort of follows on Judge Williams' last point. This is not an anti-cost-benefit analysis position, but it does question whether or not a revival of cost-benefit analysis as the way to go doesn't become a legitimizing argument for more nanny state, more regulation, because we feel more comfortable with regulation that's done with sophisticated cost-benefit analysis than we do with regulation that's done by the seat of the pants. But I guess, so I guess my underlying view is that we're doing it in any event. We're doing cost-benefit analysis, whether we're in the marketplace, whether it's Congress passing the Endangered Species Act, whether it's an agency. And so the real question, or an important question, ought to be one of institutional competence. Where is the decision best made in light of the kind of information that a particular institution has access to and the kind of competence it has to make decisions, and that there isn't one world of decision making and then the world of cost-benefit analysis. It's cost-benefit analysis everywhere, and so the more important question is where is it done and where is it most competently done?
Yeah, let me stick up for OMB here. I mean, this
doesn't happen very often.
This was Susan's job for a while, so I won't make her say it. But I mean, this is the role of OMB, and in particular the Office of Information and Regulatory Affairs that Susan used to head up. For the significant federal rules, there is the cost-benefit requirement under the analysis requirement under the executive order, and all those rules have to be cleared by OMB. And so OMB has a lot of, well, not enough, but a fair number of very talented people who do this regularly, and are probably the people who are the best suited to do it. And that's why, you know, from the beginning of the Reagan administration on, through a number of different administrations, it's up to OMB ultimately to look at the agency's cost-benefit analyses and, you know, either sign off on them or reject the rule. And as a practical matter, I think what happens oftentimes is, you know, some rules OMB will agree with as they come to it. Others, just no way to sign off on in any shape or form. But more often, you know, there's going to be a back and forth between OMB and the agency on, well, I can see, you know, a fair amount of this rule making cost-benefit sense, but you know, you overlook the following fairly significant considerations in your analysis, and once you do that, it's hard to see how you get this standard as opposed to that standard. And then you end up with some kind of discussions that hopefully lead to the agency modifying the rule, OMB approving it in a way that makes more sense than it went to OMB. And so the whole idea of OMB is to have, or that part of OMB is to have a group of people who are very good at this, who do quite a lot of this, and have also the political backing from being within OMB to get the rules straightened out. That's, I mean, in my view, that's where it ultimately should be done, and where, at least in theory, is being done.
And let me add to that and bring back to the previous Hayek question. One of the things that OMB looks for is it asks two questions before it gets to examining the benefit cost analysis. And the first is there a government role in the first place? Or is that knowledge base that you're talking about really with individuals to make the decisions? That what Hayek talks about, the circumstances of time and space. The
basic proposition is that incredibly widely scattered knowledge
it's
held
the
by
wisdom of
7
crowds,
billion
right.
people gets distilled through the price system into something usable by everybody.
And that no matter how sophisticated we are as a government, no matter how good and careful our benefit cost analysis it can't compare to that wisdom of crowds, of people making those decisions. So that's one of the first steps. So it may be that the knowledge base that you're talking about isn't at OMB or at the agencies, but it's really in individuals. And then the second question the OMB guidelines say to ask in the executive order is the federal government the right place? So maybe it is a government, does need to be a government decision, but is it the federal level or is it at the state level to make that decision? And then only after you've answered those two questions in the affirmative do you get to, let's pull together the data we have and do a benefit cost analysis.
I mean, in a way, what we're actually talking about is these are, at some level, terms in a cost-benefit analysis. Because, say we were imagining alternative ways of, say, doing greenhouse gas regulations. There's a command and control style that you could adopt, or you could do a carbon tax, say, on the other side of the spectrum. And we would say, well, you know, one of the problems with the command and control system is it doesn't it requires the government to do all this information process, which is costly and which is going to generate errors. And this alternative tax system is going to allow the marketplace to do more of the information processing, which we think is going to do better, which it probably can do cheaper. And so that actually ends up being a term in a cost-benefit analysis, again, when looking at different ways of approaching a regulatory problem.
I think that's right. I think it's important to think about alternatives within the benefit cost analysis. But my point was a little different, and it was before you even start to do the benefit cost analysis, you have to decide, is this a public problem that we have to decide collectively, or is this something that's best left to individuals operating through the market system? And I think that has to be the first step, because otherwise you'll do things like, I think we get this fuel economy regulation that purely because we in the government do some analysis and we know better what car is suited to you and you and you than you do. And I think that's the first step we have to do.
Nobody want to attack or support cost-benefit analysis.
Let me just take a minute then to stick up for the moderator. When people are talking before about the American Trucking Association's case, I'll be brief on this. The problem that Judge Williams had, and it was a huge problem, was that the D.C. Circuit had been holding for more than a couple decades that the statute did not permit cost-benefit analysis. But EPA throughout that time had not been promulgating zero-level standards, which meant that there was some basis, unknown basis, for not promulgating zero-level standards. And that does look like an unconstitutional delegation. You need some intelligible principle to figure out what to do. And there just wasn't one based on the D.C. Circuit's longstanding interpretation of the statute. That was right. The problem was that legally it got split up into two questions in a divide and conquer kind of way, where the Supreme Court first said, well, EPA has been saying for decades, D.C. Circuit's been saying for decades, Congress hasn't overruled it, so we'll stick with the original statutory interpretation. You can't consider costs. It then turned to the second level question and said, we haven't heard of non-delegation in 6 decades. And when you split those two up, they work together on their own, but together, I mean, it leaves you with the same problem that Susan was talking about, which is, if you take that decision seriously, you ought to have zero-level standards,
Right. Absolutely.
which you don't. And that was why non-delegation was a somewhat creative way of trying to deal with an obvious problem. But the problem
Creativity is a terrible accusation in
No,
an official world.
but I mean, and the problem does remain because of the way the Supreme Court handled it.
I mean, the alternative framework would be to say that the agency, in not adopting a zero, a zero level, is outside of its jurisdiction under the statute. That would be the alternative. But of course,
No party
right, who wants
has
to bring
come
that?
forward
Right.
pressing that claim,
Right, I mean,
for me at any rate.
No.
Right. 'Cause environmentalists won't do it because they don't want to blow the rule, and
Right.
the industry doesn't want a zero standard.
A couple of questions that I think are related. One is, when doing the cost-benefit analysis, how much do agencies look at impacts on employment? Because it does seem that many regulations really, if they ban a certain way of doing things or a certain type of business, are going to have adverse effects on employment in certain sectors. So one question is, how much do agencies look at that? And then second question is, how much do they look at kind of the cumulative effect of this regulation that comes on top of all these other regulations that a company has to live under?
I'll take a quick stab. Agencies often in their regulatory impact analysis have a section that's cost-benefit analysis, which tends to just tally up total costs, total benefits, and all the non-quantifiable things. Then they also often have a section that's the economic impact analysis, and that one is more what you're thinking about with employment. It would look, are there particular segments that are more harmed in terms of either employment or higher prices for consumers? Say my brain. What was the second part?
Oh, just the cumulative effect, is this the straw that's going to break the camel's back? Or?
I think we're less good at that. I think we're less good at doing that, both on the benefits and the cost side, knowing what the incremental impact. And it all, one of the key parts of doing a good benefit cost analysis is what we call the baseline or the counterfactual. What would the world look like if not for this particular regulation? And that's very important to get right, and it's also very hard to get right. And looking at the cumulative effects is part of that.